Chapter 5 School Officers 1. United States Commissioner of Education. By Act of March 2, 1867, Congress established a department, since known as the Bureau of Education, for the purposes of collecting such statistics and facts as shall show the condition and progress of education in the several states and territories, and of diffusing such information respecting the organization and management of school systems and methods of teaching as shall aid the people of the United States in the establishment and maintenance of efficient school systems, and otherwise promote the cause of education throughout the country. It was established as an independent bureau, but was subsequently attached to the Department of the Interior by Act of July 20, 1868. The head of this bureau is called the Commissioner of Education, and it is his duty to present annually to Congress a report embodying the results of his investigations and labors, together with a statement of such facts and recommendations as will, in his judgment, subserve the purpose for which the office is established. In the centennial message of the President, an amendment to the Constitution was suggested which should make public education a subject of national cognizance. As the matter now stands, public instruction in this country is left entirely to the states, each of which frames and regulates its own system by appropriate constitutional provisions and legislation. Although in the different states the details vary, yet the management of the schools is in the hands of officers chosen by the people, and whose duties are everywhere much the same. The national government has been very liberal in the donation of lands, and of the proceeds arising from the sale thereof, yet the schools have been supported mainly by voluntary taxation, voted by the people, and this taxation and the apportionment of interest on the permanent funds have necessitated the employment of officers essentially the same in nearly all the states and territories. It is the object of this chapter to present the decisions upon questions of official duties and liabilities which are common to all the states. 2. State Superintendent of Public Instruction. The State Superintendent of Schools, or Superintendent of Public Instruction, is the highest officer in the common school system. This office exists under some title in every one of the states and territories, and in those states in which attempts have been made to abolish it, the movement has proved disastrous to the school interests, and the office has been restored. It is generally the duty of the state superintendent to supervise all of the public schools in his state, to call upon the officers under him for reports upon matters concerning which they are by law required to gather information, to ascertain the number of children residing in each district and the number attending school, the amount paid for salaries, the number of schoolhouses and the amount expended in building schoolhouses, and to report this information, together with such other information as he may acquire concerning the operation of the common school system. He also tries and determines appeals from inferior officers upon questions of school law, and perform duties pertaining to the distribution of the state school funds. He ought also to recommend such changes in the law or such additional legislation as he may deem beneficial to the system of public education. The duties of this officer and the law governing his actions are usually made explicit by statute. 3. County Superintendent. In most of the states there is in each county an officer known by the title of County Superintendent, or some similar title, who serves as the organ of communication between the state superintendent and the township or district authorities. His duties vary in the different states, but it is usually his duty to gather statistics as to the number of youth of school age in the county, and in each school district therein, and the number taught, and such other information as is necessary to exhibit the true condition of the schools under his charge. This is embodied in a report to the state superintendent. It is also generally his duty to examine applicants for teachers' certificates, and to grant certificates to such as possess the necessary qualifications, and to exercise such supervision of the schools in his county as will advance the public interests in the matter of education. In some of the states, particularly the New England states, there is no such county officer, but the reports from the towns are made directly to the state superintendent. The county superintendent is not entitled to an injunction to restrain one from teaching on the ground that he is teaching without a certificate of qualifications. Where the statute vests a discretionary power in a county superintendent in granting licenses to teach, the judgment of the court will not be substituted for that of the officer, and mandamus will not lie to compel him to issue a license. but where he wholly fails to act on an application he may be compelled by mandamus to take action thereon. It is a general principle lying at the base of the law of mandamus that the courts will not interfere with nor attempt to control the judgment or discretion of any officer whose official duties call for the exercise of some degree of judgment or discretion. Where such an officer wholly refuses to act, mandamus will lie to compel action, but not to control such action, nor to substitute the discretion or judgment of the court for that of the officer. An officer whose duties are judicial or quasi-judicial is not liable for errors of judgment or discretion in the discharge of those duties unless he acts from corrupt or malicious motives. In an action on the case against the superintendent of schools of a county for illegally revoking a teacher's certificate, the plaintiff, in order to show malice, is not compelled to prove personal hatred or ill will, but if the defendant acted rashly, wickedly, and wantonly in revoking the certificate, the jury may infer malice. 4. Directors, trustees, etc. A. Their powers and duties. A board of school directors, though a corporation, is possessed of certain specially defined powers, and can exercise no others, except such as result from fair implication. In Iowa it is held that the duties of school directors respecting the discharge of teachers, imposed by Section 1734 of the Code of 1873, are of a judicial character. The officers charged with the control and management of the schools have a right to dismiss a teacher employed in said schools upon breach of the contract, either by reason of failure to teach or because of incompetency. And such officers are not liable in damages if they honestly err in the discharge of this duty. If they act wantonly and maliciously, it gives a cause of action against them personally, but malice and injury must be affirmatively shown to have been the impelling motives, even though no reason was assigned for the removal of the teacher. A letter from an inhabitant of a school district to the school committee, complaining of a school teacher, is privileged, if written with an honest purpose and for the public good. Where a suit is instituted in the individual names of school directors in reference to a matter in which they are only interested in their corporate capacity, it is proper to amend the title of the cause by striking out the individual names of the directors, and substituting their corporate name. The individual names, in such case, are regarded as surplusage. A suit or defense for a district must be conducted in its corporate capacity by its proper officers. An individual member of a school district has no right to appear and be heard in defense of an action against the district. A verbal contract of a school board employing an attorney is valid although never entered on the minutes. In Iowa, the president of a school district township has no authority to employ counsel at the expense of the district, unless in a suit brought by or against the district, and an appeal to the county or state superintendent to contest the correctness of an order of the board is not such a suit. The board has no right to make acceptances of orders or bills of exchange so as to bind the district, unless expressly authorized by statute. Where a board of education is, by statute, made a body corporate, individual members acting separately, although a majority, cannot contract a debt thereof, or direct the issuance of an order to pay it. School officers are not liable to an assignee of a school order for constructive fraud in issuing an order they had no power to issue. In Kentucky, school trustees failing to raise and collect the school funds as required by law are personally liable to the teacher for a failure to pay him his salary as agreed. Power to establish and keep up a system of graded schools implies authority to appoint a superintendent thereof. A member of a school board or school committee has a right to order from the schoolroom a boy who addresses him, in the presence of other pupils, in a profane and insulting manner, and where the pupil refuses to go he may be ejected, no more force being used than may be necessary. In such a case the pupil cannot recover as for a wrongful expulsion. B. Their contracts. A member of a district school board cannot make a contract with the board of which he is a member, for the building of a schoolhouse. Such contract is void upon grounds of public policy. The board of directors of a district township has no authority to purchase lightning rods for schoolhouses, nor to give the obligation of the district township therefor. School charts, exhibiting and illustrating matters to be taught to pupils, are not necessary appendages to a schoolhouse. In Iowa, the board of directors have no power to make contracts for the purchase of maps, charts, and other school apparatus. without being previously authorized by a vote of the electors. The directors have no power to make an express contract of the character specified, unless thereto authorized. They could not so act as to raise an implied contract, or ratify the express one by the acceptance and acquiescence in the use, by the schools in the sub-districts, of the apparatus purchased. That such maps, charts, and apparatus were by the board distributed among the several sub-districts, and used in the schools thereof with the knowledge of the directors and electors, and that no steps were taken by the electors to repudiate the contract, does not amount to a ratification of it. Nothing short of an express ratification of the electors in their corporate capacity would suffice. An independent district may provide for the teaching of music in its schools, and the board has power to purchase by verbal contract a musical instrument to be paid for out of any unappropriated funds of the district. There is a marked difference between the rights of an assignee of a school order and those of an assignee of a promissory note or bill of exchange. The assignee of a school order must at his peril ascertain what defenses may exist against its collection. An action may be maintained against a school district on an order drawn by the proper officer thereof. The creditor of a corporation is not restricted to mandamus as his sole remedy. Where a person acts in his official capacity, which is disclosed in the contract itself, he is not personally liable on the contract, although he has failed to affix to his signature his official title. C. Their liability for negligence. No private action for neglect of corporate duty, unless given by statute, lies against any quasi-corporation as such. In the absence of a statute creating such liability, a board of education is not liable in its corporate capacity for damages for an injury resulting to a pupil while attending a public school, from its negligence in the discharge of its official duty in the erection and maintenance of a public school building under its charge, nor for an injury sustained by a scholar attending a public school from a dangerous excavation in the schoolhouse yard, owing to the negligence of such school board. But in Bassett v. Fish et al., 19 N.Y. Supreme Court, 12 Hun. 209, it was held that the trustees of the Union Free Schools, having the duty imposed on them by statute of keeping schools in repair, and being supplied with the necessary means, they are personally and individually liable to any person for special damages sustained by reason of omission or negligence on their part. This was reversed in the Court of Appeals, on the ground that the trustees of a Union-Free School District is a corporation complete, and not a quasi-corporation, and that the individual trustees are not liable, the negligence being the negligence of the corporation, for which it alone is liable. 5. Treasurer. The liability of the treasurer of a school district is absolute for all funds which come into his hands in his official capacity, and in case of loss cannot be varied or diminished by reason of the cause or manner of the loss. Where the loss occurs through the failure of a bank, the treasurer is liable on his bond, although he was not guilty of want of prudence or care in failing to ascertain its financial condition. Where the treasurer deposited money of the district with his banker to his own individual credit, which money was intended to meet certain bonds of the district then about to fall due at, and which were payable at the same bank, and the treasurer so informed the banker, and directed him verbally so to apply it, when the bonds should be presented, and while the matter was in this condition the bank failed, resulting in the loss of the money, it was held that the banker was the agent of the treasurer and not of the district, and that the money was recoverable by the district in an action on the treasurer's bond. The treasurer is liable absolutely for all money of the district coming into his hands, which he has not lawfully disbursed, and the school district has no power to release him from a liability for money lost or misapplied by him. And where he resigns and absconds and fails to pay over the money in his hands, as such treasurer, to his successor, no demand therefore is necessary to maintain suit upon his official bond. If a school treasurer releases a mortgage siren to secure a debt due the school fund of his township, without an order of the board, he will be liable upon his official bond for any loss sustained in consequence thereof. 6. Vacancies by operation of law. The acceptance by a school officer of another office incompatible with the school office renders such school office vacant. The duties of teacher and school trustee are incompatible, and the appointment of a trustee as teacher, and the acceptance thereof, renders the office of school trustee vacant. The offices of Prudential Committee and Auditor of a school district are incompatible, and one who is elected to both offices at the same meeting and accepts the latter thereby declines the former.